session as a speaker. So I think there are more than 2-3 sessions has already done because this FDP started on 25th of May. So today we are going to discuss a lot about IP, how IP can work into academia, and how we are able to generate revenue from the IP, what is technology commercializations, what is the global ecosystem of intellectual properties, why academic institution has more towards intellectual properties. So there are so many questions maybe in your mind. There are so many facts, myths about intellectual property, how IP is working, is IP is a scam or what, why we do IP, what is publication in IP, how it is differentiate between, how we can differentiate between IP publication and research publications, and what is the major aspect of IP, what impact it will create. So we will discuss all of these points. So, to be very honest, before we start this session, I don't want to be like a puppet and I will just speak. So I expect we there will be a two-way communication where you can ask a lot of questions and maybe whatever the time I'm debating here, so it will be utilized in a good conversation. So, am I audible to everyone? First of all, you can just thumbs up if I am.
Yes.
Okay, good. Thank you. Okay, so in your previous sessions, I hope you have already gained a lot of knowledge about what is intellectual property, how it is working, and what is design thinking. I think that you have gone through the session from design thinking. What is innovation? What is innovation in businesses? What is innovation in intellectual property? I want to ask you one question. What is innovation? What do you mean by innovation? Anyone here who can tell me what is innovation? Because I think you have done 3 sessions on innovations, design thinking, strategy making. Anyone here who can tell me what is innovation? Strange. Okay, no worries. So let's start this session. Hope we'll discuss things in further. Is my screen is visible to all?
Yes, sir, it is visible.
Yes, sir, it is.
Yeah, I think you should allow participants because it is popping up in my screen again and again.
Sir, they are allowed to unmute themselves.
Okay. Okay. So today's session is Global Intellectual Property Landscape and Research Innovation Ecosystem. To be honest, this title is given by the chat GPT, but we will not consider the point from the chat GPT. We'll consider the point from the experience that I have been into. So basically, I have been into intellectual properties from last 5-7 years, and in that I have registered and granted more than 105 patents. Patents, designs, basically designs are the part of industrial designs. We call it design patent in India usually. So our session objectives are like what is IPR in academia that I already discussed, explore global IP framework, types of IP in protections, bridge research plus IP innovations, understanding university innovation ecosystem. So I hope everyone who is here are the professor or scholar or a faculty member. I'm assuming it. And you are a teacher teaching in a multiple organization institute. There must be a criteria by the NIRF and NAC to be fulfilled by the faculty members and the organization to gain some certain number of points. I think I am right. So For that thing, there is a department which was organized, that is IPR cell, inside the multiple organizations, where we file our patents and designs according to the academy institutions. So today we are going to discuss about how we are able to make out patenting things with our institutions. Why we need to put our institution inside our patent, and why NAC and RF is looking for IPs. What is the agenda behind the AICT? What is MOE? So we will discuss all these points in today's session. Okay. So in the beginning, roles of patent and research is one of the segment that we will covering right now. So why researchers should do understand IP? See, uh, first thing that I want to clear in the all the academicians' mind, like intellectual property in academia and intellectual property in businesses are the different segments. So let me take you from the very basic thing. Right now, I'm not talking about what is IP and what we need it, but I'm just talking about how IP ecosystem works in academia and how IP system works inside the businesses. So, for example, you are a professor, you're doing some research, and on that research, you find out like you are this IP this research is having some novelty, some claims that I'm making out. My readings, my output are novel. So, academic institutions having rights to file an intellectual property, any sort of intellectual property, can be patent, can be industrial design or a design patent, can be a copyright or trademark or a GI. After filing that patent on your research, you will get a certificate of grant. And then, after utilizing that grant, you are having the options to go with the startup or to commercialize it. I'm saying two things here, to go with the startup or to commercialize that thing. So both are the different segments. Like making a business is different and commercializing it is a different segment. Now, if I saw this from the business mindset, if I am a business owner, if I am an entrepreneur, so what I will think, okay, I am working in some scenarios and I found out like my supply chain is having something novelty. There is some novel thing inside my supply chain and my processes where we are running whatever we are running in our businesses. So as a business owner, I am having the rights to take a IP, whether it can be a trademark, copyright, patent, or anything. So from the business mindset, I am increasing the valuation of my business after doing IP registration because IP gives you the monopoly. IP gives you the monopoly rights. So uh, can Dr. Komal, can you please help me out because I think people are joining again and again, so it is popping up on my screen. Am I audible, Dr. Juhi, Dr. Komal?
So you
Uh,
are
d-
audible.
yeah, I think can you please check out lobby again because people are joining, so it is just popping up on my screen. So I'm
We are looking for
it's
it, sir. Thank
yeah. Thank you. Yeah. So right now I'm discussing about like why academic institutions need the IP and why businesses need the IP. Academic institutions need the IP to fulfill some criteria which is given by the NAC and IRF. Also, there are some fundamental and non-fundamental researches which are those who are novel into the market according to the academic institutions and the professors. So to secure that novelty, to secure that research, academic institutions and professors go for the intellectual property rights. But businesses goes into intellectual property rights to make the monopoly into the market because they want to secure their business inside that country. So basically, whenever we are as an academician, I am having rights to fulfill and to secure the IP for my research. Businesses do that to secure the business monopoly. Now let's take one example for this. For example, I have done some research, a non-fundamental research on a pharmaceutics department, Department of Pharmaceutics, or in the Department of Computer Science. I have made something which is very novel, and I am having the theoretical part of it. So what I can do after that thing? I am having the options to do a research paper writing, or I am having options to do the IP along with the research paper. So I choose the both segment, IP and research, and I have registered it. But in a business thing, in academic things, I don't want, or maybe I don't require to go out in another country to register the same technology or the same research. So basically, let me give you a more brief about IPs. IP is a territorial rights. Territorial rights means we can apply our intellectual property rights inside one territory, like in India, in Africa, Australia, America, or many other countries. Why it's a territorial rights? Because it's a law. It's a legal tech law, or it's a law where people can secure their creations. So basically, intellectual property rights give you the wings to secure your creations in different departments. We will discuss later on what are those departments. Uh, Now, why academic institutions are working into the to enhance the intellectual property? Because there is a segment that they are doing, and this already happens inside government organizations like DRDO, ISRO, CSIR, DSIR, and many others. What was that thing? Let me tell you. First, they will give you the awareness of intellectual property. This is what is happening in previous years. If we see in 2021 or 22, there was a boom in market to do the intellectual property awareness drives, to do the incubation drives and all. After that, what happened? They insisting you to first they insisted you to do the filing of a patent. Now they are insisting you to get the publication of a patent. After that, right, in the current scenarios, they are asking you where is the grant of that IP. I'm talking about the NRF and NAC accreditations authorities, what they are asking from the institutions these days. In future, maybe in 1 2 year, they will insist you to give the commercialization strategies and how many IPs are commercialized inside your institutions. So this chain is already like in progress or in process or in use in many organizations like DRDO, ISRO. So similarly, this model has been utilized by the UGC to enhance the IP portal, to enhance the IP portfolio of India. That is why previously people are insisting to do the IP filings, then they are looking for the publications of IP, then they are looking for the grants, and now they are looking for the commercializations. Okay. Today, we will also discuss about like why people choose the rubbish ideas to do the patents. We also discuss about how you can attract investors for your IP. Many people here maybe have having good knowledge in startup incubations and all. So there are many banks, those who give funding for your startup, your registered company like LLP, private limited, or many others, right? But have you ever seen any bank is giving the loan for patent? Have you ever seen that thing? Like any bank like SBI or any bank is giving loan for patent. Many banks give loans for startups, but not for patent, because also patent is one of the thing which you are having. It's an intangible property. Anyone here? Any bank you know? Okay, okay. So there is chat box also. Innovation means something new and beneficial. Thank you, Miss Anjali, for society. Okay. No, no, no. Okay. Right. Your slides are not visible, not changing. Are my slides are not changing? Can anyone give me the confirmation, please? My slides are not changing because I'm not because only stick on. I'm right now on this page only. Don't worry. If you are talking
So
about this slide, yeah,
now the
I am
slides are changing. Previously,
okay.
they were not.
I am on second slide right now. I am speaking only on this slide. There are
Yes,
so
sir.
much of content I'm having. So okay. Now we are moving to next slide. Did it change? Now we are on another
Yes, sir,
slide.
it changed.
Okay. Okay. Now I am just speaking on that slide. Okay. So now let's talk about what exactly intellectual property is into the market. See, intellectual property, like I have already discussed, there are two parameters, one for academics, one for the businesses. Today we will go in depth in the academics, but also we will cover the business strategies. Okay. So there are two types of properties in this universe. One is tangible property, another one is intangible properties. All tangible properties are those properties, those who we can touch, feel, or sense. But there are multiple other properties which we cannot touch, feel, or sense. So, okay. So, can you give me one example of intangible property? Any example of intangible property you have seen in your day-to-day life?
Copyrights or logos.
Goodwill, patents. Yeah, patents are the tangible property. No, I'm asking for example. Yes, trademarks, logos. These are intangible properties. I can understand, but I'm talking about the you use in day to day life. What platform that we are using right now? Teams. Yes, to Zoom Teams. Right. This is an intangible property. A software is an intangible property. Right. So these things are intangible properties in that we use in every day. Music is also an intangible property for the entertainment business. So very simple to understand. See, IPR is very simple. So many people are thinking about like, wow, somebody has so much of IP. He must be a crazy guy or must be a very scientific person like Einstein. Einstein is also the person who was a clerk in IP office in America. But uh, IP is not that much critical. Finding out the loopholes is critical. Finding out the loopholes, what we can secure as an intellectual property. What is creation for intellectual property? How many departments in intellectual property are? If you are aware about that thing, so this become very simple for you. Very simple. So creation of mind, invention, and designs brand comes under the intellectual property. So basically, intellectual property works like and acts like a superhero for the people who are the creators. Creators can be the inventors, scientists, professors, music composer, painters, artistic material makers, anyone, any creator. So intellectual property gives you the rights to secure your creation. Simple. Now, it gives you the monopoly rights and self rights like you own that particular segment, no one else. So this is two, three things. I have already discussed why intellectual property is territorial rights because it's a legal, it's a law. For example, I am a person who's living in India. So all the laws, maybe the traffic laws, was implemented on me inside one territory is an Indian law. For example, I am driving a car. So if I have registered my license in India, so that is also a territory defined. So definitely, I cannot utilize my driving license until it's international in America or in China or Japan. So similarly, to do the same, there are different processes as well to make the international driving license, or I have to give again exam in America, Japan, or China to obtain by another driving license. So similarly, if I have done something or secured something in India as an intellectual property inside the intellectual property, so I have to do the same in different countries if I have not done anything internationally. That's why it's a territorial rights. So if I have registered my, for example, I am the inventor of the Samsung pencil. So if I'm the inventor of the Samsung pencil and I've invented this in India and secured in India only, so the intellectual property rights does not implement it or secure my invention in America or in China. I have to do it again until and unless I will file something internationally. Okay. You see, guys, if you are going to ask anything in my inside this conversation, so you just can turn on your mic or you can raise hand because it is very difficult for me to check out the chat box. Or if you have write something, just raise your hand. Okay. Any questions still here? Maybe not because this is very simple. Okay. Again, it gives you monopoly and fixed time, encourage innovation, protect intangible property. That's it. We know it very well. Now, strategic role of IPR in academia, it is very important. Very, very important. How it is important for academic institutions? So it is very simple. See, there are professors, those who are a researcher. If researcher having something which is credibility to increase the credibility of any industry, so they are having the option to secure their novelty, to secure their invention creation through intellectual property. Now, NAC, NRF, and other organizations comes into the segment because they think our academic institutions must be well, like high class or something which can be the competitor of other countries' institutions with the help of intellectual properties. Similarly, it will increase the mission of Viksit Bharat, or which is going on 47. It will increase the mission of uh, Make in India processes and other government strategic things. So, but but this is there is one fact also. 99.99% intellectual property which comes from universities are rubbish. Nobody wants it, not even in India. This is the true reality as well. Why they don't want it? Because I will tell you it in okay, let me tell you here only. What we are doing these days, for example, I'm a professor from XYZ University. I'm a scholar from XYZ University. If I think my invention, my research is very unique, okay, wow, then what I will do, I will make it and I will secure it inside the intellectual property and I will make a showcase to everyone that I have done one IP. But what is the use of that IP? Because you have not connected with any industry, those who are going to license it, those who are going to commercialize it. For example, I have connected with Mahindra's and Mahindra is making one car. And I'm Mr. Venkatesh Bharti, have already done 10 years of research on something which can be utilized inside the automobile industry. But before connecting with the industry, I have invested my 10 years, I have invested my money. And after making that thing, I am going to Mahindra's like, sir, I have made something. Can you please accept it? They will say no. Why would we accept it? Because this segment, whatever you have created, it's not a plug and play model, first of all. Another thing, this is not our problem. But the solution you are giving, it is not our problem even now. Can you make something else? They will say like this and invest more 5-10 years. Because today we are giving you a problem statement. What is happening in academic institutions? They are just filing patents, doing publications, filing patent, doing publication. I will tell you a lot of things today about what is the publication and all, because by doing even publication, if you are not secured, if you think you are, you have done something in publication, you can be inside the courtroom as well one day, because you are becoming the competitor of the industries by filing XYZ patents. So this is also the thing which is happening in India. We'll discuss. Okay, it encourage innovation culture, attract industry collaboration and funding and all. So yes, it do, but very less, 0.2%. Okay, let me give you one more example. Like from last 2023 to 2026, there is again hike of 256 percentage of patenting. 256 percentage of patent filing in India. Can you imagine? 256%. But how many of them are granted? How many of them are commercialized? 0.2% is commercialized and 0.9 is granted. 0.9% granted. What is the meaning of those patents? Nothing. Okay. Now, why IPR is critical for researchers? This is also very beneficial thing for the because researchers works under the segment of thesis and all, and if they think their output, their system, that the process that they have created is novel, so they are having one opportunity to secure it under the IPR right. So many researchers are doing fake patents, like they are doing fake patents, they are going for the scammers. And why do they have the need to do it? Patenting is very simple thing. Find out the good concept, find out something which is very unique. Uniqueness is does not directly proportional to something which is not existing inside this world or in this country. Uniqueness is something which is innovative. So we'll discuss about it. This is also one of the loophole. Convert research into tangible assets, one thing. Build academic reputation and citations, and open door for startups and grant. So basically, whenever a scholar, uh, so whenever a scholar file for a patent, they will have one of the things, that is, after filing a patent, I am having again two segments. Do I need to go with for the my further academic career, or now I can create a startup as well if it is well established? So there are multiple options they can have. Okay, now let's discuss about the Indian patent ecosystem and global ecosystem. Very simple. Indian Patent Office having four offices: Delhi, Mumbai, Chennai, Calcutta. Delhi, Mumbai, Chennai handles patents and patents. Other office which is left, like Calcutta, handles design patents, which is industrial design, and handles trademarks. Now again, Startup India missions, AIC supporting awareness. I know, I don't think so. I think so that you are aware about what is Startup India, what is a Atal Innovation Mission, IIC, Institution Innovation Council. Why IIC established by the AICT? Why it comes under the picture? Because to help the faculty members and students to go inside the incubation culture, to go inside the entrepreneurship ecosystem, incubation ecosystem, startup ecosystem. After getting the knowledge of, after getting aware by IIC activities, you will be able to make yourself a entrepreneur. You will be able to make yourself a startup owner or a founder once in our life. This is my recommendation. Whatever you're doing, please do one business in your life always, because it will help you to imagine different perspectives. Okay. Then there is WIPO, which is World IPO Organization, which handles by 193 countries, those who are into the same treaty. Okay, then there is a PCT system, international filing, where you can file 153 countries. Similarly, like if I am filing a driving license in India and I want to file for the international, so how many countries will be covered inside that international filing? So PCT, Paris Conventional Treaty, the full form of PCT, help you to sorry, helps you to file patent internationally. I will. Okay. Also, for example, Okay, I will take it from the patent example, not here. Let's go. So this is the major concept of today's session. Here we will discuss a lot of things. Okay, so let me go back to the screen. I'm okay. How many of you are aware about what is patent? Ever in your life, like have you ever heard about the thing patent? I don't know, like how I have visited to DIAS 2 3 times. So if the faculty members are here, so they know very well. How many of you are aware about what is patent?
So just patent or total IPR, intellectual property right you are talking about.
I'm talking about patent.
Patents are being applicable for tangible properties, and it should be novel, it should be functional, and it should be commercialized, or it should have an industrial application to it. That's the
Okay,
basic definition for patent.
okay, okay. Thank you. What's your name, ma'am? Anjali. No,
Ravleen Kaur.
Ravleen. Thank you, Mr. Ravleen, for giving information about patent. So anyone else who wants to discuss about what is patent? Because if you know patent, I will ask you certain questions, and then it will be more creative to find out what it actually is patent is. Anyone here? 65 people are sitting here. One member is from my team, so 64. Okay, let's take an examples now. So this is the bottle of Vedika. So can I file a patent on this if I am the novel inventor of the this bottle? So please listen my question first, then give the answers. I, Venkatesh Bharti, is the whole sole inventor of this water bottle. I invented this today, right now. What's the time? It at 2:45 p.m. on 28th of May. Can I do the patent on this? I'm talking about patent, not design patent. I'm talking about patents. Can I file a patent on this? Okay, now again. Now this is the cap of Vedika's bottle. Can I file a patent on this cap? I am the wholesale inventor. Don't be confused. We are not going to judge you here if you don't even know the answer. When I started, I don't know even anything. So it's not a big deal. Okay, Anjali Gupta ji कहते हैं कि yes. Anyone else? Can we file a patent on this? Then we will discuss about what is patent. Hmm. It's not. Yes. It's not novel. Okay. Good concept. But today I have made it like I am the wholesale inventor of this. Okay. So let's go forward. Basically, we will not take the patent on this because it's not novel. It's not about it's novel or not. There are some other factors that we have to discuss. So basically, what is patent? So before that, before going into the departments of patent, let's discuss about what is intellectual property and why we call it patent, industrial design, design patent, trademark, and all. Let's assume a college. Let's assume a department. Uh, let's assume DIAS. Okay, Delhi Institute of Advanced Studies. DIAS is one of the major key component, like parent or depart organization, right? Then there are Department of Management, Department of Sciences, Department of Mathematics, Department of Physics. All right. So one thing, to get admission inside the any of the department, what is the first criteria inside an institute of a college of IP university? You must clear 12th exams, right? You must have the certification mark sheet of 12th, passed mark sheet, right? Right. CUT exam, right? This is the first criteria. Now, to choose the department, there are the subject matters. Like if you want to go into management, you must have the commerce background, science background, humanities, arts background, and humanities background, right? Similarly, now let's assume intellectual property rights and department of IP. IP is the main department. So to enter inside the intellectual property department, I must have a creation. This is the first criteria. Now, next is in which department I will register my creation. That is a subject matters. Now there are another filterization processes and registration process and criterias where I can register my different creations and nothing else. So patent is nothing. Patent is a department where we can register our creation. Trademark is a department where we register our creation. Different creations. Right now, I'm just talking about the patent. So any creation which can be registered under the Department of Patent. So there is nothing like patent. There is a Department of Patent where your creation has been registered according to their criteria list. Now let's talk about the criteria. I think now patent has been cleared. Then we will discuss the criteria of a patent. First and most important criteria of a patent to a creation to register inside the like register inside the Department of Patent, that is, it must be a process first. Second, it must be a technical process. Third, it must be a composition. Fourth, it must have industrial applicability. Fifth, it must have inventive steps. And sixth, the most and the last, it must be a novel process, invention, composition, or a technical process. These three criteria you have to fulfill to file a patent in India. First thing. These are the technical code thing that required to file a patent. Like name, your email ID. These are the requirements also. But how you identify this particular segment going to be registered inside a patent? Why? Clarifying these six criteria. Now it's very easy to understand. Now let's take again that example. Can I register this water bottle inside the even if it is novel? Look, okay, now we consider all six criteria. This water bottle cap is novel. I have invented this. One checklist, fine. Inventive steps are the steps which we write. So I will make and hire one good attorney, patent agent, and he will write out my inventive steps in a legal format, whatever the format given by the Indian government. So checkpoint 2 is also fulfilled. Now third, is it industrial applicable? Yes, it is industrial applicable, can be utilized in many water bottles and industries. Third criteria fulfilled. Now, which is the fourth criteria? What? Is it as a composition? No. Is it a technical process? That's why this water bottle cap cannot be registered inside the segment of or inside the department of patent. This is what we call product patent and process patent. Now there are two things in patent. What is product patent and what is process patent? The thing that I'm showing is a non-technical product which cannot be registered inside the department of patent. This this mobile phone is a technical product. This mobile phone can be registered inside the department of patent. A mobile phone can register inside the department of patent, but a cap cannot because cap does not consist any technicality. Now let's come to the process patent. The manufacturing unit having the capability to register to manufacture this cap, is it a technical process? Yes. The machineries, those who are making this cap are the technical process, having technicalities. So we can patent the process of making a cap, but we cannot patent the product delivered by those machines. So there are two differentiations between process and product patent. A process can be patented, sometimes a product cannot be. A product can be patented, sometimes the process cannot be. So we have to identify that thing. Okay. Now, another thing. Can we do a patent by combining two innovations like innovation A plus innovation B equals to innovation C? Yes, we can. But we have to utilize the loophole. Sometimes people say, I have utilized ultrasonic sensor. Have you ever heard about ultrasonic sensor? Any sensor? No. Okay, let me give you example. Yeah. Okay. So here is one watch. There is another watch. Okay. It's a analog watch, and this one is a digital watch, right? Both are watches. Okay. So which one comes first? This one, analog one, right? So somebody, what somebody have done? He took the analog watch, okay, and added the digital screen, which is already existing. So he took an analog watch. For example, I am the inventor. I took one analog watch and I have added the digital screen inside that analog watch, and I am representing that this watch is having a screen. So is it a novel thing or not? Screens are utilized for what segments? In mobiles, but never in watches. Similarly, एक छोटा सा example और देता हूँ if you can understand. Uh, like this is a massage gun. Okay, so we are utilizing guns for armored vehicles for army, right? But right now we have changed the shape and made it a massage gun. The concept is similar, but the output is different. When the output is different, so we have done the similar, we have utilized the similar components, we have utilized the similar or existing things, but whatever the output that they are delivering is unique. So on the basis of the output, we can take the patent. If my air conditioner will become a air purifier, so I can patent it because the process is same, but the output is different. How the output is different? Somewhere the process will be different. We all know air conditioner will work on compressor, right? Compressor is a machine where inside the, have you ever opened a compressor? I don't think so. I have opened it. So compressor, inside a compressor, there is a magnetic motor. It's not hollow. There is no gas. So inside a compressor, there is a motor which work and compress the air, not the air, the gas.
जा रही हूँ मैं तो वहाँ
हाँ,
3 बजे वो आया हुआ है ना हम खाना तो हम खाए 3 बजे
okay,
वो आया था ऑफिस से आज
okay. So so after after doing the compression, what if we remove the compressor and then what we do? We put mobile phone there still, or a football there. We have removed the compressor and we have put it the football there. Can I take a patent on that air conditioner kind of thing again? Because in the previous existing model of which is already patented, there is a statement a novel device which can produce cool air with the help of compressing air, which is done by a compressor. This is the title of the previous air conditioner. Now, what we have changed, a novel device which can produce a cool air with the help of a round shaped object like a football. Any questions here? Because I have explained so much. You can turn on your mics if it is possible, because then only we can go for the further IP process. See, patenting is something we can change the technical process. What is patenting? Like in this motherboard, okay. So there are so many components which are connected with each other, right? Like this Type C charger, this buttons, these screen segment, everything is connected with each other from point A to B, B to C, C to D, till Z, till the output, right? Everything is connected with each other. If we follow that thing, it's a process. Is it a process of technicality? Yes, it's a process of technicality. Similarly, in composition of a pharmaceutical medicines, if I talk about some medicines, if you talk about paracetamol, so there is a composition by some like putting some this drug, combining this drug, then making a chain of that drug, then observation. This is also a process, comes under the patent segment. Okay, so this is what IP is. Basic of IP. How we file it, what is the registration, how we register it, something else we will discuss right now. But till here, any questions to anyone? Okay, cool. Good afternoon, ma'am. Okay, so here we understood what is patent. Now, these three key concepts. See, these three key concepts has been taken up by the IP government when they check the patent. Patenting is something like where people can check your like when you do exam, when you give exam, so there is an examiner who check your paper. Similarly, when we submit our intellectual property or creation, so there is an examiner who check your examination sheet. Similarly, your patent submission of a patent inside the Department of Patent. So they check it and they will check on these three criterias. Also, they check on those three more criterias, like is it composition, it's a technical process or not. Also, because these criterias is just to check the formation of your patent submission and nothing else. We have already discussed this. Now, this is very important segment. If there are faculty members or researchers here. Okay. So The mechanism has been changed. This is for 31 months now. So please consider this not a 48, 31 months. Okay. So what is the procedure of filing a patent in India? Here we will discuss a lot of things, and I request you to please check it out. Like if you will not understand this, please just drop a message or raise your hand. When we are having a idea, we make the inventive steps. We file our patent through Form 1 application, Form 2 application, Form 3 application, Form 5, Form 9, and Form 18. I will showcase you the forms. I will showcase you everything there. But so keep understand, like just imagine you are having all the forms. You are having all the you have like registered all the forms, and you are at the filing stage. Day one. Let's assume today is 28th. So 28th of May or 27th of May, I don't know. 28th of May. So what we do today, we are filing our patent application. Now, after filing our patent application, we are having 18 months. In this 18 months, in these 18 months, our patent application will be published automatically. Now, what is intellectual property publication or patent publication or any creation publication? Publication happens on only in trademark, or sorry, in industrial design, which is design patent, or in patent, IP Act. So, what is publication? Now, let's take an example here. I am Venkatesh Bharti. I have registered one patent. Okay. So there is X entity, which is me, as an as a V, Y entity V, and then there is X entity with names Ramesh. Let's take Venkatesh and Ramesh. Suresh and Ramesh sound good, so we will take Suresh and Ramesh. So Ramesh have filed one patent application today. On which day? 28th of May. Now, after after 1 year, on 20th May 2027, just assume Suresh has filed one application without checking anything. Without checking anything. I am again saying without checking anything. Ramesh filed 20 on May 28th, May 2026. Suresh filed same application with like similar sort of application on 28th May 2027. Now, what mistake has Suresh has been done that is not checked that this patent is in market already or not? So how will Suresh will check? If he will check it again, let's assume Suresh has not filed yet, but he wants to check whether uh, okay, whether this is a Samsung pencil. This pencil has been already registered by Ramesh. Now Suresh also made one of the pencil and similar pencil which having different color combination. Button is there are two three buttons. This is having single button, but work same, the output is same. Suresh is also want to file such patent. He has also invented this. Where will Suresh will check like is the similar application is present or not? Right, WIPO or Indian Patent Office. How? If it is not published, so how? Why publication is required? This is what I am saying. What is publication? Just for other patent applicant कि भाई पहले एक application file हो चुकी है and nothing else. But in India, people considering publication is an winning statement. No, it's not. It is just to check, is this application is published or not? Is this application, is this invention is in public or not? And nothing else. So don't consider publications a winning statement, because this is a human, there is no human intervention. Publication is a computer generated process. If you will give me two eyes, one nose, two lips, 2 ears with one specs like me in a photo format, I will submit form 1 and form 2. My face will be registered in publication, which is useless because nobody have seen your application. So publication is only for the awareness for another applicants that such kind of application is already into the market and nothing else. Research publication is something else where you gain citations, where you gain different logics. Because in research publication, you have, after publication, you are certified that this publication is done by you and your concept is unique and good for suitable for the market. But patent publication is just for awareness and nothing else. Okay, now let's move forward. Before going forward, let me give you here those people who are filing patent applications, those people who are filing patent applications and getting publication done. And after publication, they are thinking that we are achieving something and we achieved something. So let me give you one eye opener thing. If now let's take an example. If any organization, for example, I have filed a patent on this pencil, all right, and if any organization like Samsung only or Apple finds out uh, there is a person, Venkatesh Bharti, this we can find it out by doing due diligence. So Apple, the people who are sitting in Silicon Valley or somewhere, anywhere where they are manufacturing it, or strategists are sitting somewhere, find out, oh, there is a person in India have filed a patent application similar to our pencil. Okay. Okay, no worries. We are having one opportunity, pre-grant opposition. We call it pre-grant opposition. Pre-grant opposition is something like, how dare you to file a patent application which is similar to our system, our device, which we are utilizing from last 20 years. Who are you? Why they are doing it? Why they are having the option to go for the pre-grant opposition? Because if I patented this device, so I have the monopoly to sell this device in India. So without taking the approvals from me, Apple or Samsung cannot sell this product. So they have to give me the royalty, and I can ask n number of royalty after seeing the valuation of this pencil. For example, this pencil cost and gives the projection of 50 crore in India in a year. So I can ask 10 CR directly. So publish, if anyhow any organization finds out your publication was rubbish but contradicting with their product, they are not going to leave you. This is reality. If you are novel, if everything has been checked inside the prior art, there are searching techniques where you can search out that your patent is novel or not. So there you can find out. The next process is request for examination. Here what we found, like, then there is a request for examination. I will go little for like in fast mode because already I'm having 53 minutes. So request for examination is something like, here after publication or before publication also, you are requesting the examiner, can you, sir, can you please check my exam sheet, can you please check my patent, is it novel, industrial applicable, or is it having the inventive stuff? Okay, then an examiner will be appointed to your application. He or she will check your application from IP India, and then they will issue you a report of examination. We call it first examination report, FER. FER. After getting that report, again you have to file the response on that report. And examiner from the examiner, you got some objections like, Mr. Venkatesh, you have to remove this. This is also contradicting with the patent application which is present in China. This patent application is contradicting with the present application which is present in America. So don't you IP give you the rights to make the territorial, but for checking and examination, whole countries have has been filtered out, like this application having the contradiction on any other application in other countries or not. So it will be checked whole by the inside the whole world. Okay. Now next, there is after filing the response, now again you are having two things. If the controller will be satisfied, if the examiner will satisfied, okay, your application is having all three things, you are good to go, well and great, then they will give you the grant notification. Okay, you are going to get the grant. You can make yourself little excited. But if he is not satisfied, so you have to present inside the hearing. It's a hearing. There will be a hearing process. You have to satisfy the controller that my on those three terminologies and explain your technology. And after that, again, if it is good to go, he will give the grant. If it's not, go for the refusal here only. After getting the grant notified, again, grant notification, even after the grant notification, again, the people who are into the industry having the rights of 1 year, they can oppose your application. How dare you, controller, to give the grant even? We are already uh we are already selling this product from last 70 years. You are no one to give the grant again. So again, you have to compete with the industry leaders. After leading this competition of at least 3 years, this is the 3 year process, and by expedition, you can go with the 2 and 2.5 year. So after 3 year, you will get grant. This is the whole process. Those who are getting publication in 2 months, uh, I'm 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 just saying, if you think that your application is good to go, then only proceed. Then else don't. I know API score, maintain your CV, but please keep yourself away from pre-grant opposition and post-grant oppositions. That's it. Okay, I will discuss question in further slides because I'm having less time. From required form, okay, these forms are required for the patenting applications. Form 1, 2, 3, 5, 9, 18. Form 1 is applicable for the new application. Here you submit your email ID, your phone number, your name, your title, your normal KYC document sort of things. Now in form 2, there is a provisional and complete specification form. Provisional applications are those applications where you have not concluded your invention research. Okay. For example, I'm doing research from last few years and I'm not concluding it yet. But the research is very important. I have to secure it anyhow. So by putting few of the points or something, you are just taking the provisional application, and after that you are having 12 months of time, means 1 year, to complete your research and file for the complete specification. Complete specification can be directly filed if you are having the conclusion of your research. Now, third one is statement undertaking under Section 8, that you are the whole sole inventor of this country. Declaration inventorship, that we are the true inventor of this. These are the little forms. Declaration are the inventorship, like you are the true inventor of this country. Form 9 is an optional form. For people who want early publication in 2 months, they file Form 9. And if they don't want, so automatically the publication will be done in 18 months. And Form 18 is for the request for examination, like examiner, sir, can you please check my patent application? So Form 18 will be filed for those things. to request for examiner to check your application. Okay, let's move forward. Let me show you if we will take 1 minute only. So how an FER looks like. This is first examination report. It is comes like from Government of India. There are the novelty, inventive, or industrial applicability. You have to be yes. My inventive steps are wrong because this was my first patent I have filed. So in industrial applicability is okay, claims are okay, but inventive steps are not. So I will resubmit the application with good inventive steps. The rest is my application is contradicting in US, China, and Japan. So there are the application numbers. What are these are the applications numbers? What are the objectives are contradicting with the similar applications? Again here, and I have to send a reply of this application and nothing else. After that, the controller will be satisfied, so he will issue a certificate of grant. How the certificate of grant looks like? Let's see. This is the certificate of grant. Okay. Let's move forward. Institutional IP policy and documentations. Okay. Right now I'm still on patents. Uh, why we need IP policy and documentation in every institute? First of all, see, because in big institutions like big universities, there are already having the IP policies, like in HR or in their admissions. There will be IP policy, like whatever the thing will be registered inside the institute. So 90% will be for the inventor and 10% for the university and institute, because institute is putting money to file that patent. So that's why IP policy is very important in institutions, because it can make the contradiction between the university and the faculty and the professors and even with the students. Now, whenever you are filing a patent in institute, you must have IDF form, which is an invention disclosure form, which is mandatory, where you disclose your invention as well as you file a NDA, which is non-disclosure agreement. Similarly, by doing these such activities, IIT Madras is faculty is earning 70% royalty on their licensed IP. And there are many other MIT, Harvard are they are into $1 million. They are earning in millions through IP. Okay. IP filing steps. Idea generation can be done by the in the faculty or a student. Novelty can be checked by multiple ways. Let me show you very quickly. Okay. First, we can check the patent application, Google patent. These are the steps where you can check the prior art very easily. Google patent. Okay, let's find out something which is related to car. Okay, so just put car here. Vehicle system configured to interact with remotely located. This is one of the patent. The patent has been registered in US. We can do more filterization here by clicking here. Like what patent office you are looking for? I am looking for in India. So I'll go with India. Here is India. Okay, all the patent applications which are related to car popped up. This patent application has been registered in China, Japan, and India. Okay, let's click it here. This is registered by Hitachi. So this is one of the segment where you can check out the patent applications for the prior art. These are already published and granted. So you can also filter more, put more filter here, like status, grant application. We are looking for applications. So there are the applications. Grant means the people who have certificate. So this is the one way, which is Google patent. You go with the Google patent. I will put it here in chat box for you. Google patents. Now, the next one is our IP India portal. How to check out in IP India? Very simple. Go on patent segment section, click on publications. Okay. Now I will show you the journals which was published, and also I will give you the options to do the track of applications. Okay, so these are the journals. Every Friday, IPDA showcase the journals, how many patents are published. So these are the patent applications which are published this week, last week, sorry. Tomorrow another will getting open will take time. It's Indian website. So here we can check our application status. If you are having anything, you can check it out very easily. Okay, now we click on patent search application. Uh, okay, how we can check? Let's find out. Applicant name. I will write my name. I don't know I'm having any patent here or not. QQ MYIC. Again, it's getting loaded. Okay. So these are the patents done by Venkatesh Bharati's. Let's like find something. Uh, and we can go next. Let's click here. There are more. Okay, so this is again rolling. In the meanwhile, let's check the journals. These journals are open to everyone. You can check it out. From here, you can identify, are you doing anything which is not contradicting to any other application? If it's not, then go for it. Before it, please check by yourself. And there are some other tools as well where you can check it out. I will tell you the tool's name. In the meanwhile, you can check journals here. For journals. Okay, so this is the journal. Okay. So this is how the journal looks like. There are 1690 pages in one journal. So you can imagine how many patents are filed every day. So many. So this journal was published every week. You can imagine more than 3-4 thousand patents published every day, every week. Okay. My laptop got stuck. Just give me a second. Okay. So we can check the documents even here. What document they have filed. We can click here. After clicking here, you can get the documents. It's opening. In a meanwhile, uh, let's cut it here. I have showcased two things. Documents are getting open. Now, in the meanwhile, we can check out. This is WIPO portal, World IP Organization. Now, what WIPO work like do here? After no, there is not alone. You can also share the where we can got all. No, you have to check out every portal. But there is one thing which you can do. It is WIPO. WIPO, like there is a WHO. What WHOs do, they regulate the policies for all countries and holds the data of each and every country related to health, right? Similarly, WIPO, World IP Organization, secures the data of IP from each and every country. So after publishing, your application will be transmitted to WIPO. So whenever a controller wants to check, okay, this application is already, because sometimes we are Indians, na, we are very jugadu. So what we will do, we will find out, okay, some American Mr. Robot has been filed one patent application, let's copy it. So how will we check if the database was not at the central level? So WIPO considers the data at central level, and everyone can check like, is this patent is available or to do or not. So to identify that thing, we are having the portal WIPO where you can check very easily. Let me tell you. Okay, so here we can check out like advanced search. We go for the advanced search. Again, I will write my name. I am checking it in India. Right. What I am checking, I don't know. Okay, let's see what will come. Okay, so now this is my Angarakshak element, which is already present on IP India, and even on WIPO. This element was given to DRDO. So, this is my another novel device to produce electrical energy using the vibration generated by its surroundings. A novel health diagnosing system using multiple sensors. So these are my patent applications. If I go inside, these all are patents. Okay, this is the application number and all. So this is present on WIPO. So if anybody wants to check any helmet related thing which is related with the soldier safety and all, so this can also be present at WIPO level at the central database. So central database handles all the patent applications. Similar with the designs as well, I will showcase you designs. So okay, there are more than 50 plus designs still here. So all are like made by me, Venkatesh Bharti. There is more, many more. I don't know, maybe 200. So Venkatesh. So there are so many designs, there are so many patents. I don't know the number of designs now. So it is very simple to identify like are we are on the right track or not. But you must have the right links to click. Okay, so I am sharing you the links here. You can check out by your own at your home. This is for design, this is for IP. And now we are moving forward for other things. I don't know, it's open. Yes. Okay, so these are the forms that we can check it out very easily. Complete specification, declaration, drawings, and all, and check out like what is inside the application. So we don't have time, so we are moving forward. We are still only patents on the patent side. There are more things. Okay. Now we are coming back to industrial designs. So previously we were discussed about what is patent. Okay. So now we are discussing about what is design, what is industrial design, what is design patent. So basically, a thing like design patent is nothing. It's just the creativity done by the academicians to, in a layman language, we call it design patent. So there is nothing like design patent. There is only one thing, which is industrial design. So I have asked you one question. Can we register this as a patent? No, we cannot register this as a patent, but we can register this as an industrial design. This can be registered as a design patent if I talk about in the layman's language. So now what is industrial design? Previously we discussed about the processes. Now we are discussing about the shapes. How anything appears. Okay. Let's take the example of a car. Like let's take the example of Fortuner car. I hope everyone have seen the Fortuner. So how Fortuner is working, the process of running a Fortuner. Fortuner has been run by engine having valve, radiator, steering wheel, how everything is connected with each other. It's a process which is technical, can be registered under the Department of Patent. Now, how Fortuner is looking like? What is the structure of Fortuner? What is the shape of the Fortuner? What is the color of the Fortuner? Where we can register it? This can be registered under the Department of Industrial Design or into the design patent. The shape, structure, color, pattern can be registered under the Department of Design Patents. So, also, uh, uh, okay, I will discuss it later in trademark segment. Basically, be sure industrial design are always a 3D model. Like it must have X, Y, and Z axis, which is perspective. So it must have into the 3D structure. There are so many industrial designs: jewelry, chair, Lamborghini, heels, shoe, clothes, and water bottles. It is very easy to change the designs and make different. If this is a yellow color bottle, so I can color it green, blue, red, black, narangi, whatever it is. So, but we can take it as an industrial design, because taking an industrial design is just changing the color, shape, and structure. Okay, let's take another example. Uh, Again of this water bottle. Can I register this water bottle into the design patent segment if it is novel? Yes. Yes. Right. Now, can I register again it? Can I again register this water bottle inside the design patent segment again if it is already registered? Am I audible to everyone here? Okay. Okay. Register then? No. Okay. We can register this water bottle again and again. The number of time I will tell you, you now if I'm hello, am I audible? If I am putting the cap number 3, okay. If I am squeezing this bottle like this, number 4, so I can register this water bottle 4 times. So I will have 4 design patents one by one. Even if I go with this, okay, I'll take the example of my. Let me take out pen. Sorry if my throat is paining today, so I cannot speak properly today. I'm not little well because of my throat. Okay, so this is a pen. Can I take a design patent on this if it is novel and invented by me? Yes or no? Maybe yes. Because this is invented by me. I am the whole sole inventor of this. How many design patents I can take on this? Number 1, this steel part. Number 2, this cap. Number 4, uh, this particular portion. Number 5, number 6, number 7, number 8. And when I am fitting this pen and making it 1, number 10. So I can take 10 design patents on design in this. And if I change the color, this is gray color, then red, number 11, white, number 12. So anything can be possible in design patent, but you have to change the shape, structure, and appearance. Okay. Even if you are having a plate which is having the flowers, like 2 flowers are printed on one plate, 3 flowers are printed on similar plate, 4 flowers, the counting has been increasing, the appearance has been changing. So we can take design patents again and again. Very simple. Okay, let's move forward. This is the structure of design patent. I will not go in depth because I don't have time to secure, but I will tell you very simple. It is a actually 6 months process, but sometime it will take one year because our IP India does not have human resource to check so much of design patents. So they are overloaded. Here also you file my application. There is also formality check. One examiner will be appointed to your application. Then again, it will check on prior basis in the worldwide, like if any other application is similar to this or not. If yes, so they will give you the objection and they will discard your application. If no, they will proceed for the certificate. But one thing is unique here. In patent segment, the application can be published within 18 months or 2 months, but here the application will be published on the day it will granted. Why? The application will be published on the day it will granted. Like the grant in patent application can be done in 3-4 years, but in design patent it's a 6 month process. But still, it will the publication will be done on the day of grant, because the design can be changed just by shifting or changing into the appearance. Even the 1% changing appearance, changed in appearance, can lead to another design. That is the reason, to secure the privacy, what we can call it, to secure the appearance, the application will be published on the same day when it is get granted. Because anyone can, like if I have made one cap, if you have ever seen Shark Tank, there is a person who take the who introduced his cap in Shark Tank, and maybe Ashneer Grover asked him that you have design patented it. He said yes, and then Ashneer Grover said the infringement, and like infringement is like something cheating. Is done in design very easily. So he said yes. Just by changing the shape, color, appearance, you can change. You can take the design patent again. But again, there are loopholes. Many people don't take patent on design patent on colors. They take design patents on shape only, because if anybody like infringe with our shape, so we can sue them, because we don't have colors. We are open for every color. Have you ever seen any car Baleno? Have you ever seen Baleno car of Maruti? You have seen a gray color. You have seen the blue color, the favorite blue color of Baleno. There is a blue color Baleno, dark blue color Baleno. So that blue color was design patented on Baleno. Also, I will showcase you few of the examples of design patents which are inside our Indian jurisdictions. You will be surprised like how many design patent are registered by a car company. Each and every part that you see in a car is already design patented. Okay, let's take applicant name containing Maruti Suzuki. Okay, so this is the front grille garnished set of vehicle, front grille plate of vehicle. This is the proper part. This is the side panel, like where mud flap of a car. All the component has been registered by Maruti Suzuki to make the monopoly that nobody can check, nobody can make their alloy wheel in this market like this, similar to this. All are non-technical. Dashboard, even the partition trim of the dashboard. Front bumper of, I think this is for of Swift Desire. So even floor mats are registered inside a design pattern. There are how many? Let's go to the last. There are 26. Full Baleno has been registered inside a design patent. Who is the applicant? Maruti Suzuki India Limited. Nobody can copy the design of design like how Maruti Suzuki Baleno looks like. So this is the power of intellectual property, where you can register the whole. You can check out the Lamborghini registration here. See the Wagoner. Have you seen the Wagoner? Wagoner has been registered by Maruti Suzuki with no color, because they want to secure the shape, not the color. So these are the things. Again, this is the Brezza. Maruti Suzuki Brezza, registered under the design patent segment. So this is the uniqueness of where I am. Okay. Now I think you have understood what is design and what is patent, right? Now let's go forward. To file a design patent, it's very simple. Form 1, which is journal form, where you fill your all information. Then cover letter, then representation sheets. Representation sheets consist 7 views of your application. Like 7 views, like, okay, many countries. This is the perspective view. Similarly, left, right, top, bottom. These are the perspective views. So, okay. Give me a second. Let's go to this. Okay, we can see here only. This is the perspective view. So left, right, top, bottom, and perspective. No, sorry, front and back also. These are the 7 views that we have to paste of any object, our device, component, accessories, anything. All right. So we have to represent that thing inside the sheets, like maybe a PDF file, not maybe exact the PDF file, and we will register it. This is the design patent, how it is looks like, certificate of design. Then there is trademark. I will ask questions in the end. Just allow me trademark and 2-3 things. Okay. Now there is trademark. Trademark is something similar to design, but it is a 2D structure. Design, industrial design is a 3D structure. It does not have third axis. So it's on paper. So basically, trademark is generally secure your brand identity. It can be a word, it can be a name, it can be a device, symbol, logo, label, anything. Basically, it can be a monogram. It just secure a brand identity. One more thing, trademark are there to register your brand identity and secure your brand monopoly inside the market with the name. If I call about Mercedes, Mercedes build car, right? Rolls Royce build engines, not cars, basically. If I talk about McDonald's, they make burgers. Burger Sing, burgers, right? So why it is important? Starbucks, what Starbucks makes? Starbucks make coffee. If I take, okay, so let's take example. What is the importance of trademark? Again, I will disturb Ramesh and Suresh. So there is a person Ramesh and there is a person Suresh. So what happened if there is a person Ramesh, Suresh, and Mukesh? Mukesh is the person who is coming back from Greater Noida, and he had a very good coffee at Starbucks. Just an example. He comes to us, he comes to Ramesh Suresh, and he was just starting talking about, like, guys, I just had a amazing coffee. I'm just forgetting the name. And what he googled a best coffee place in Greater Noida. Eventually, there is a not Starbucks, it's Sardar Bucks. Okay. There's a name popped up which is Sardar Bucks. But actually, Mukesh had a coffee in Starbucks, not in Sardar Bucks. So if he wants to identify which one is the authentic, he has to look the trademark logo, right? Which one is having TM, or which one is having R, or which one having nothing. So similarly, in trademark sections, you cannot take name with the similar pronunciations. So if I want to register, so eventually what happen if the Mukesh and Suresh will goes to Starbucks, not to the Starbucks. If you can imagine every day 10,000 customers who are going to pay 100 rupees to Starbucks are diverting to Starbucks. What is happening? The sales of Starbucks is getting down and the sales of Starbucks will getting up with the just because of the wrong pronunciation of name. So that is why in trademarks we don't have the capability and the criteria that even the name should not be similar in the pronunciation even. It must be unique. We cannot take the name of Starbucks as in Starbucks because the pronunciation can make lead to the market and the valuation losses inside the balance sheets of many companies. Okay. So similarly, this is only the trademark is how to identify which trademark is registered and which trademark is in process. The companies, if you see, there is a TM, right? The logos which is having TM means the registration is not completed yet. That means Starbucks having the TM means they are under the process. They does not got they does not have the grant certificate till now. The companies those who having R means registered. So those organizations having the registration certificate of a trademark. Okay. So this is all about the trademark and this is all about the, here are so many trademarks inside here. You can check out Ford, John, Starbucks, Android, McDonald, and Vodafone, Levi's, Diva, so many here. All right. Now let's talk about copyrights. Just give me a second. Okay. Sorry. So now let's talk about the copyrights. Copyrights are something which where people who are having the artistic work can register their creations. In Department of Copyright, we are having rights to register our artistic work inside the department. So there are so many artistic work that can be literature, painting, photographs, drawings, music, films, choreography, sculptures, or books, guggle, poem, and road art, street art, anything which is having the artistic works. I mean, literature, there are so many things. The research paper also comes into the copyright segment. Books are considered a copyright segment. Even a line comes under the copyright segment. So, so we can copyright anything. One more thing, copyright is a self right. Means if I want to register a copyright, I don't want. I am not. I'm just having a one line. I am having a poem. I will take it and drop it and post it on Facebook. I will post it on Instagram. Eventually, after posting on public platform, you will get a copyright. That means not everything need to be copyrighted inside the copyright segment, but the things comes under the literature work. Like if I have write 250 pages of book, so I will not upload it on copyright on Facebook, right? To get the copyright. So many times that you have seen, there are people who are getting the copyright strike on YouTube. Their videos has been deleted on Instagrams because Instagram, these public platforms provide you the self-right opportunity. Copyright is a self-right. Whenever it is comes by you inside the public domain, it's yours. But it must be a artistic thing. Okay. This is copyright. Now, now there is geographical indication. Geographical indication is one of the segment that I think each and every person is aware about, but maybe they are not aware about what is GI. So before this, I just wanted to ask, do you know what is GI? You know what is GI,
So it is basically property right based on any geographic. For
right?
example,
Absolutely right.
mangoes or silk. So basically, Kashmiri apples, we say.
Right, right,
So
right.
that
You're
is based
absolutely right.
on basmati chawal and all. So these all are based on particular geographical indicators, and that
Right,
are only produced in a particular geography only.
right. So you are totally correct. Uh, GI is something which is a department which give you the indication that in your geography you are creating something amazing, and we are approving it with the tag of GI. That's it. There are two, three criteria to get a GI. One is environment, another one is skill set. One is environment means I cannot grow Darjeeling chai patti in Delhi. I cannot grow Alfonso mangoes in Delhi. I cannot make basmati rice, grow basmati rice in Delhi because the geography, the environment will suits to the growing of those things. Now let's talk about the skill set. I cannot make Pashmina shawl in Delhi. I cannot make Kanchipuram sari in Delhi. So these are the few sectors. Depends. So I cannot make doesn't mean I cannot sell. The manufacturing cannot be done outside that geography, but the selling can be. It's very simple. So there are so many GI tags in this world. In India also there are so many Basmati chai, Kanchipuram sari, Banarsi sari, Alfonso mango, Bikaneri bhujia, Nagpur oranges, Pochampalli, Chanderi sari, Chanapatna toys, Salim fabric, Kolhapuri chappal, Kolhapuri missile, Tirupati laddu, Goa cashew and all. So there are so many multiple states, multiple uniqueness. Okay. Now there is one of the segment which comes under the which comes under the intellectual property, but we are not having anything to secure this. This is trade secret. Have you ever seen the Coca-Cola formula? Have you ever seen the Oreo biscuits formula, Pepsi formula, Starbucks formula to make coffee? These all are the trade secrets. The ingredients are the trade secrets. So we secure our ingredients, pattern, process, methods, tools, automations inside the trade secret segments. Have you ever seen how Google search algorithm work? How Google search algorithms work? We have not never seen that thing. It's hidden. It's secured inside the trade secret segments. Even Oreo biscuit and Pepsi formula are having the bunker from to save them from the nuclear. I don't know why they have made the bunker because if there is no human who will eat that thing. So there are some example of KFC formula, WD formula, Coca-Cola formula algorithms, Google search algorithms, which can be secured in the trade secrets. If I'm talking about the patents here, patent patents are like have you ever seen the patterns on sari, suit, clothes? There are patterns, similar patterns. Such patterns are registered inside the trade secret segments. Okay, now we are at the uh, stage. Now we have to know like how long that we can secure such kind of things. So for patent, you are having 20-year protections. Like you are the owner of something for 20 years, but you have to renew it every year. Trademark is lifelong. After that, after 10 years, you have to renew it. Design is 15 years. After 10 years, you have to renew it. Copyright is for 60 years. No need to renew it. GI is lifelong, and after 10 years, every after 10 years, you have to renew it. What if you will not do the renewal? It will comes under the public domain and nobody can take it into the IP segment again. Also, there are so many case studies that we can discuss here. One second. Okay. Now simplify the IP is very simply. Here, okay. This is a Samsung Galaxy S20 mobile phone. If we talk about how this mobile phone is working, the process of working, the technical process, where we can register it, that is patent. Now, what is the logo? Where we register the logo of the this Samsung Galaxy S20 trademark. How this mobile phone is looking, what is the structure, what is the appearance, where we will register it in industrial design or design patent. When we open this mobile phone or whenever there is a tune will comes up like ting 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 whatever it is, how where we will register that musical composition, where we will register that tune copyright. So in this mobile phone you are having everything: patent, trademark, design and copyright. All right. uh do you have any question till here? Anyone? All right. Anyone? Anyone else having any question? I don't know you guys are listening or not. Oh, yes, sir. No, sir. Okay. I'm moving forward then. 7 minutes. Okay. Research to IP conversation process. It is very simple. Identify novel ideas. Finding out novel ideas is not a big deal. Tomorrow's session will be amazing on startups and businesses. So we will discuss about what is actual innovation, how it can be proceeded to businesses and models. Tomorrow we will discuss this. Conduct a prior art search, which is very important. Before proceeding that you are thinking the idea is novel, please do the prior art search because your thinking does not matter here. Then evaluate the patentability, what we can do into the patentability section. Draft IP filing, draft the form 1235918. Then develop a prototype. Okay, commercialization. There is a segment which is commercialization, which is very important. We will consider it right now. To commercialize a thing, to commercialize a technology, to commercialize an idea, patent is not required, research is not required. What required is that is prototype. It says POC, that is MVP, minimum viable product. POC, proof of concept. We need the prototype. If we are having POC, prototype or MVP, we are able to commercialize anything because every industry want to see the implementation part, not the documentation. So now let's talk about commercializations. What is commercialization? Commercialization is something where you are able to generate the revenue out of your research, your patent, your any creation. There are few segments. There are three segments: licensing, selling, which we call it technology transfer (TT), and the last one is joint venture. Licensing is something like I am a person who have invented something. I am having a patent. I am having a prototype. Now I am giving this prototype for the mass manufacturing to Tata Consultancy Services, sorry, Tata Services, to L&T Larsen and Turbo, to Mahindra, to any big organization, those who BAE. So I am giving my concept to for a large manufacturing. That means I have given the licensing opportunity to make my product for a manufacturing unit for the production. In that licensing process, I will get some fixed cost. Also, I will get some royalty. In licensing, you get royalty only and only in licensing. Then there is selling. Selling, we also call it technology transfer. Here we have directly and fully given by our technology to one organization, and after doing the technology transfer, we are not having any right to that technology. We have taken the fixed cost and okay, bye bye. Again, next time we are not eligible to take any sort of money from the organization. Then there is a joint venture. What is joint venture? Joint venture is something I am having patent, I am having 1 crore rupees, you are having business, you are also having 1 crore rupees, I am giving my 1 crore, I am giving my patent, you are giving your production, you are giving your office. We will jointly make one organization which will be known as a startup. That is a joint venture. So IP commercialization is something like making money out of your perfect IP effectively. So there is a process. There are multiple processes. First process, You do research. Here also you do research. But you work on prototype, then you work on patent, then you make startup, then you go for funding. Here you make research, you do patent, you incubate, you grow, and then you go to market. So this was done by the businesses. This was done by the academic institutions. Because business is having money to make prototype. After they think, okay, patent can be taken on this product, they will take product, then they can make on a individual startup on it, and they are having the opportunity to get fundings, and after getting the fund they go to the market. But academics, what they do, they first do research. Okay, they will file patent because they don't have money to do make prototypes. They incubate themselves. What is incubation? Incubation is a womb like structure where startups nurture themselves. Okay. Incubation is something where startups grow effectively with a ecosystem where our mentors, funding opportunities, networking opportunities are there, and they get fundings from government and private ventures. There are multiple sources of fundings from CSR, private venture, equity, seed funding, bootstrapping, capitalizations, both mother. There are so many things. I will discuss it tomorrow. Okay. So this is the flow. Linking research with the traditional approach and modern approach, there are two kind of approaches. Okay, one is traditional approach, you do research and you publish it. Modern approach, you do research, then you do patent, then publication, then commercialization. Publication means research publication. Because modern solution, okay, if you are talking about non-fundamental, fundamental researches, so go with the non-fundamental, you will never get something commercialization. But if you go with the fundamental researches, you are able to get commercialization very easily. India is one of the sector, those who largely work on pharmaceutics commercialization and on nothing else. Because in India, there is no mechanical industry, there is no automobile industry, there is nothing else. India is not a manufacturing hub. So, but India is very good in pharmaceutics. If we talk about in COVID era, so India also the owner of Serum Institute looking for the Covaxin. I don't know what we have made Covaxin or Covishield. So they are asking for the patent, but according to Indian patents law, we cannot patent those medicines, those medical equipments which are for the public causes and for the public health. So if they will take the patent, so eventually uh, they are the richest person more than the money and Adanis. Also, there is one of the best example where humanity comes first, money comes later, which is Volvo, because Volvo have invented the seat belts and they never took the patents. Okay, there are some schemes where you can get the patent reimbursement. If you invested 50,000 on patent applications, so you can reimburse your money from here. SIP scheme, SIP scheme is from IP India, MSME scheme is from the MSME industry, Startup India Seed Fund scheme. We call it SISFS schemes. This is for startups and they can take the reimbursement of their patent application filing. DBT, DST, BIRAC are the government organizations which are associated with each other by DBT and DST. DST is for scientific and DBT for the biotechnologies. Tide 2.0 and AIM, both are the similar kind of thing that helps startups to grow with the good innovation ecosystem along with the IP setup. I'm sorry, I'm speaking very fast, but I have to finish this out. Okay, how IP can be managed inside the universities? First, they have to create the IPR cell. We will discuss about TTOs later because in India there are very less institutes those who are having the TTOs. Like IIT is having the TTOs, AIMS having the TTOs, even some good organizations also having the TTOs like Sharda and others. Create faculty incentive programs. This is for the HR policies, maintain patent portfolio and dashboards. Because after maintaining the patent portfolio, like DIAS have invented and registered 60 patents and they are having a patent portfolio, that means their students are well capable to be transform their innovation into the startup ecosystem. So this is very important. Like Stanford University earns $65 million annually. $65 million are a lot of money. And also you can link your PhD with IP. Okay, this is simple. Startup India, Indian government support, DPIT, seed fund, MSME. I have already discussed this. Challenges which was faced by the academic institutions is very clear. Lack of IP awareness, focus only on publication. Faculties are only focusing on publication. I don't know why, but what they will do after those publication, are they become richest faculty in this world? I don't know. But if you are find out the good research which can be a revenue generable for you, then you can become the richest faculty or a professor. Lack in IP awareness, like many people think trademark is patent and patent is copyright. So this is the one of the thing. But now after the IIC event, it has been screened out that many faculty members are aware what is it. Okay. Now, okay. Now we are at the end of this faculty development program for my day on this session. So every great question plants a great seed of innovation. So it's over to you guys. If you have any question, you can ask related to faculty, startups, IP, funding, how to get funds and all. Any questions to anyone?
Good afternoon, sir.
Good afternoon, lovely.
I have a query. Like, I have just now registered for a research program. I'm a research scholar. So, right now, my interest is in IPR, entrepreneurship, and SDGs.
Okay.
How can I link all of them and create a research work as well as a patent?
Okay. See, you are into the entrepreneurship, startups, and SGD, right?
Huh. Sustainable development goals,
Yeah, yeah.
intellectual property rights, and entrepreneurship. How can I link all of them and create a great research as well as can contribute to the industry?
Okay, this is the very simple, right? I want to tell you. Just visit one Atal incubation center. Visit once in a one. You can visit any iHub. Your iHub is innovation hub. You can visit any T hub. Just go to IIT Delhi. If you are in Delhi, you can visit to FITT. You can visit to IHFC. Go and check out the problem statement. Let me tell you the problem statement. Even the biggest problem statement, every incubation center, every SGT cell, sustainable development. See, we are living in India. Okay, all right. We we do puja of rivers. We do puja of Surya Devta. We know actually what is sustainability. We know very well what is sustainability, right? How we can align such things for the innovations, how we can align with the entrepreneurs. But the biggest problem that we have seen in this country, that is what is actual collaboration. People are not ready for the collaboration. I don't know why. People are not ready for the people with the like-minded people. They think they are contradicting us. They are egoistic. They are having something like that. But what you have seen whenever you visit to such innovation cell, whenever you visit T Hub, I Hub, you will face the similar problem, that is industry collaboration with these startups. People are working on startups. People are working on SGTs, right? Sustainable development growth, right? They are working on this, but for for whom? Are they working for us? No. What startup they are creating? Are they impacting something? If I align any SDT startup with the with any impactful thing, how many startups are here who are creating the impact? Very less. How many startups are creating the wealth out of their startups? Very less. Why 95% startups fails? This there is a very common question, because they are not aligned with the industries. They are not aligned. They are working on needs. See, there are the two concepts which are can be very easily identified: needs and wants. What industry wants, what individual wants. Needs of industry to automate things very easily, simply, not with the so much of technologies. Need of individuals, khana pina so jana. These are the needs. What we can innovate in this. There can be multiple innovations. Innovation is something like innovation is not a novelty. Does not proportionate to novelty, but people are not understanding. They are doing things. They are making startups. They are encouraging themselves that they are the CEO on LinkedIn. They are CTO on LinkedIn. But what actually they are doing? Are they generating the money? They forget about the sales. They forget about the impact. So if you think to how you can identify the core problem and how you will work into that thing, go and check out and pick 5 startups and compare them. How many of them are aligned with the industries? How many of them are creating the impact? How many are going to serve the needs and wants of the industry and individuals? Then you will find out like there are only 0.1%. Any other question to anyone?
Thank you so much, sir.
Thank you. Uh, okay. There is my screen. I think Dr. Juhi, Dr. Komal, I think this is end of the session. And
Yes, sir. I think there are no more questions for today's session. So thank you so much, sir, for today's session. I think we all clear about these different IPRs. So we will, I think, continue with the same tomorrow as well.
yeah, thank you. Thank you.
Thank you.
Thank
Thank
you
you
for
so much.
inviting me. Thank you. Bye bye. Have a good day to you guys. Bye.